do we have a particular criteria for witnesses? I understand that, brother, sister, cousin, who can
Because
be.
yes, we do. The witness cannot be a beneficiary. Because if you're a beneficiary, it's easy for you to say, yes, I was there. He said that because you're getting something. Unless, of course, you are an executor. An executor can be a beneficiary, but right? But
You can be an
witnesses,
executor, but you can be an executor and a beneficiary, but not an executor, not a beneficiary, and a witness.
that is correct. So witnesses cannot be beneficiaries.
Okay, good point. I just want to take a little moment to recognize some of our regulars and to welcome the new persons in. Again, it's always a pleasure to see Miss Eastlyn and Miss Wheeler. We have there. I've seen some new names. I see Miss Alexander, Miss
I don't see them. I don't have it
Ram
here.
Prasad. If you go into the private, we're in public. If you go into private, you're gonna see
Thank you.
all our all our regulars there who support us from week to week to week. So we just want to say welcome and thank you as always. So as we go back into the topic, so we understand that okay, the witness is important. They are, and that is a big pitfall because we can't find the witness. What happens then?
Right.
Witness died. Witness can be found. Yeah.
Right. Remember, the witness would have confirmed that he or she was present and would have seen you sign. The critical thing here is that the witness testifies to your signature. So when we can't find the witness, the first thing we have to do is to get their death certificates. So we have to prove to the court that they are dead. We can't prove to the court that they are dead because we cannot find death certificates. We cannot find them. We don't know their names. We can't make out the signature. The next thing we have to do is to get a document that confirms the signature on the will matches a land receipt, some receipt, a letter, or some document of the deceased. So you have to bring these signatures because remember what the witness is doing is attesting to the signature. So if the witness is not there, you have to find other documents that will show the signature, or you may find, that's right, a family member who may have been also present at the time of the execution of that will.
Now that is so interesting. So now that we have to find that's important. I mean, because I sign so differently all the time. Huh? my signature is seldom similar, but it marks that that as an important point to make sure and as close as possible sign because it could end up in contention later though.
So you know what you do for people like you? Because many persons are like you. Many. You have their ID card and you tell them, look at this signature, try to do it as near as possible to this one.
So at least you have a go-to to start.
Yeah.
That's a good thing. So we have the name all over the place. We have the location of the witnesses. What else are some of the
pitfalls? And a very important point is that some people may have property in Trinidad and but they have died abroad. That's an important, very important one. And in that case, you have to make sure the affidavit of the witness is from abroad. And more than that, you have to get an attorney abroad to say that nobody has filed for or started an application for probate in foreign. And affidavit of law is critical.
Right.
And as we're there on property, having died outside, when the attorney is doing the application, We cannot put any property you have in America or Canada or Grenada. You could only, if you're doing probate in Trinidad, you can only probate what you left in Trinidad. And then there's another procedure for property.
Wait. Hold on. So my house in the Hamptons,
right?
The other one in Calvary's Court, and the one in Bali. The legal systems in Trinidad have no jurisdiction over those properties.
That is a nice way to put it, because they are outside of the borders, the boundaries of Trinidad and Tobago. But there is a process to get to them, but you are correct.
Wow. Okay, that's news to me. In terms of,
very important.
So not even the will. So if I say I will my...
yeah, you could do all of that, you know. But what is going to happen? I give you a good example. This lady was born in England and she died in England. She lived with her husband there. He died in Trinidad. My client was the executor of his uncle's will, who was the executor of his wife's will. So what we had to do, we got the grant of probate in Trinidad on behalf of the uncle, right? But remember, the uncle was married to a lady who lived in England. So she had money in Barclays Bank in England. So what we had to do, we had to send the grant of probate from Trinidad for my client to the probate division in England. And for them to do what we call reseal it. Say, yes, this is correct. This is her husband. This is her death certificate. This is so and so. And then that now authorizes my client to approach Barclays Bank in England to get the money that his aunt-in-law left. So you can get it, but there's a procedure.
Okay. That is good to know. That is good to know, and to educate family members about that procedure, because you may want to, especially if what comes to mind, especially if a family member goes or lives or had worked abroad for a significant period of time, you need to then follow up, especially if we're dealing with the probate matter, but especially if there was no will, you need to be able to have a...
And you know why you're particularly correct? I'm dealing with another situation now. This lady is 85, and you are correct. She lived a significant portion of her life in Canada. She's a citizen of Canada, as a matter of fact. And she had, no exaggeration, at least 5 bank accounts in Canada, and shares in this company there, and shares there, and insurances in Canada, health insurance, etc., because her life was there. And she comes to me now to do a will. I told her, my dear friend, the first thing you have to do is to go up to Canada and confirm those bank accounts, confirm those shares, confirm XYZ, close them in the first place. And, send the money to Trinidad or something, make life easy. Because most of her assets are out of the jurisdiction, but she's doing a will within this jurisdiction. It's going to be hard for her executor to treat with what is out there. Bring it. So she's up there now sorting those things out, and she's in her 80s.
Wow. And that begs a follow-up question. Can you have a will that is jurisdiction bound? This is my US will, this is my Canadian will, this is my... I
know somebody who has done that. So yes, you can. However, the person who is the this is why you're going to do the affidavit of law, to find out if the person who you made the executor for the property in USA is the same person who is the executor here, or you have 2 different executors doing 2 different things, or the person in Trinidad gets a grant of probate and then proceeds to treat with the property abroad. It is very real. Very real.
Yes. That is a very very interesting component there. We have a quick set of questions here, and I want to just dive into them. Are copies of the witness's ID used to attach to the will? I guess when you are lodging a will.
No.
No. Okay. So
because remember, but it's a good question, and as an attorney, you will keep the copy of the ID, so that God forbid when that person passes on, you could identify the signature and the name, and hopefully you have the telephone number as well. So you start calling in the witnesses to begin the application process. So it's a good idea to have it. You can attach it to the will, but remember the will is a document that stands completely on its own.